Hello everyone. Today let's know, can two Indian parties choose a foreign country as the place for arbitration? In the case of PSL Wind Solutions Private Limited versus G Power Conversion India Private Limited, the Honorable Supreme Court of India held that two Indian companies can legally choose a foreign seat of arbitration. Now let's understand the background of the case. PSL Wind Solutions Private Limited and G Power Conversion India Private Limited are both Indian companies. They had a dispute and entered into a settlement agreement. This agreement included a clause stating that if any further disputes arise, they would be resolved through arbitration in Zurich under ICC, that is International Chamber of Commerce rules. When a new dispute occurred, PSL started arbitration in Zurich. A sole arbitrator was appointed and the final award was passed in favor of GE. PSL lost the case and was also asked to pay the arbitration cost. GE then approached the Indian courts to enforce the foreign award. At the same time, PSL argued that since both parties were Indian, the award should be treated as a domestic award and that choosing a foreign seat was against Indian public policy. The Honorable Gujarat High Court ruled that the award was indeed a foreign award and enforceable in India. However, it also said that interim reliefs under the Arbitration Act could not be granted because both parties were Indian and the arbitration was not an international commercial arbitration. The matter finally reached the Honorable Supreme Court of India, which made three very important points. First, the court said that the seat of arbitration, in other words, that is the place where the arbitration takes place, decides whether an award is foreign or domestic. It does not matter if both parties are Indian. Since the arbitration happened in Zurich, the award is considered a foreign award and can be enforced in India. Secondly, the court held that there is no violation of Indian public policy if two Indian companies choose to arbitrate in a foreign country. Courts must respect the parties' freedom to choose a foreign seat unless there is a clear and serious harm to public interest. Thirdly, the court clarified that Indian courts can grant interim reliefs even when both parties are Indian and the arbitration is seated outside India. This means that the parties can go to the Indian courts for temporary protection like preserving assets or staying certain actions, which the arbitration is going on abroad. This judgment is an important step in showing that India supports arbitration. It makes it clear that Indian companies are allowed to choose a foreign country to solve their disputes if they want to. This decision also gives confidence to multinational companies and their Indian branches who prefer to use international places like Singapore, London or Zurich for arbitration. If you found this video informative, do share this with others. Thanks for watching and I'll see you in the next video. Thank you.